Hey all, welcome into the EdjuristTV. This is episode number 5. I'm your host, Justin Bathan, and this is your source for conversation on law and education. Today we've just got handed down a couple hours ago the Safford School District versus Reading case. This is the student strip search case for ibuprofen, and overwhelming majority in favor of the student that the search was illegal. 8-1, with only Justice Thomas dissenting, and more his vote doesn't count anyway, so I don't feel too bad about that lone dissenter. Anyway, I want to get out there on this opinion, want to talk a little bit about it, I want to talk about the qualified immunity issue, and I'll have more analysis over the coming days, but wanted to get out there while it's fresh and everyone is talking about it. So let's talk about it. Number one, we have Justice Souter writing the majority opinion, and I think that he did a fairly good job. I'm actually in agreement with everything except qualified immunity. I thought they did a very good job of limiting the scope of this rule, and in fact I don't think this really changes the fundamental nature of school strip searches in schools at all. What we have is like a little more clarity on the sliding scale. At the very top of that sliding scale we have a little bit more clarity, but outside of that, not a big time case with a whole lot of precedential value. That said, our last school strip search case was 25 years ago, so just coming out and having another case on school searches and reiterating our findings back 25 years ago is important, and I think will be helpful for school districts across the country. That said, the one implication of this case is across the country we're going to see a precipitous drop in the number of schools conducting strip searches, which is good. Shouldn't have been conducting strip searches in the first place anyway, but now that we have some good Supreme Court precedents on this issue, we're really only going to be looking at strip searches for issues of guns. I would assume weapons will be the issue that we are going to be doing strip searches for only in the future, and possibly some issues with drugs, but it will be a very minor area. So let's get into the case a little bit. I want to get into a bit of Justice Souter's language. He has some good language that I want to highlight. As far as the facts go, I think you can get them anywhere around the net these days. I got a couple of links here in this post you can check out. But generally, the school had a problem with drugs, particularly prescription drugs. The principal conducting an investigation heard through another student that Savannah Reading was giving out drugs to other students in the school. Decided to search Savannah Reading for these prescription ibuprofen, and not very strong prescription ibuprofen, not anything that can do serious damage, but nevertheless some drugs. So searched her belongings, didn't find anything, then proceeded to strip search her, didn't find anything once they took off her outer lay of clothing. Then they had her open up, show inside her bra and underwear, and that, I think, went too far. Savannah Reading and her family brought a case, and now she has won a Supreme Court victory. Congratulations, Savannah. Those of you that follow the blog know that long ago she left a comment way back after the district court opinion. When I went out there, I was out there after the district court opinion saying this search was crazy, and so congratulations to you, Savannah. All right, Justice Souter's language, I think, is very important. Now, on the search itself, they follow the New Jersey two-part test, justified at its inception, reasonable in scope, and that together constitutes the reasonable suspicion standard. But they do give us a little bit more detail on what it takes to strip search. Now, there's a sliding scale. Okay, I'm putting up a slide. There's a sliding scale. I've been using this slide for years to tell school administrators that the closer you get to the body, the higher the level of reasonable suspicion needed, the more that it must be justified at its inception. And so I have been telling school districts this for years, as have other law people across the country, and today the Supreme Court has reaffirmed this finding. Here we go, talking about the principal. The principal must have been aware of the nature and limited threat of the specific drugs he was searching for. And while just about anything can be taken in quantities that will do real harm, Wilson had no reason to suspect that the large amounts of the drugs were being passed around, or that individual students were receiving the great number of pills. So there was no great danger to the school that needed immediate resolution. Going further, In sum, what was missing from the suspected facts that pointed to Savannah's was any indication of danger to the students from the power of the drugs or their quantity, and any reason to suppose that Savannah was carrying the pills in her underwear. So there you have Justice Souter saying for a 8-justice majority that, number one, there is not enough danger being posed to the school, and number two, you did not have enough evidence that it was on her person to justify the strip search at its inception. So, very nice precedent. Now, I will say I disagree with the finding of qualified immunity. I agree with Justice Stevens' dissent. This does not really change the law at all. The law has always been there is a sliding scale, and at the top of that sliding scale, you need an extreme amount of justification to conduct a strip search. We didn't really change the law today in this case, okay? So, my opinion is there was clear precedent that we could have found the school administrator liable in this case and not granted qualified immunity. Now, Justice Souter cited a bunch of cases saying that there was some disagreement in the circuits. That's fine, but at the end of the day, we all knew that this was an unreasonable search. We all had that feeling. Ask all my school administrators that I talked to this case about would conclude the same way, that this was over the line. Because of that, I think qualified immunity was improper. I will not address today Justice Thomas's dissent. I just don't know where he's at these days. He is out in La La Land. I think this is just another one. We saw him out there before in Morse, where we said that kids do not have First Amendment rights. I won't address it today, but I'll get back to that at some other point. So, in sum, our new Supreme Court case on strip searches, I think, is a good one. I think we have some nice clarity, reaffirming New Jersey versus TLO, and providing a little bit more of a standard when we get to that very upper echelon of searching, of strip searching. We need to have imminent danger plus a specific justification of possession on the body. So we need those two things nowadays for strip searches, and that's our new standard. And thanks for watching episode 5.